Hello, Rolf. It's very nice to meet you.
Nice to meet you.
To this interview.
Thank you. It's my honor.
So, can we start by telling us just how long the legal conflict has been going on for?
Sure. It's been going on a little less than a year from our end. The proposal for the project on the Wheelock tract started, I think, somewhere in 2014 or 2015, the first talk, which I wasn't privy to, but only exists in board records, came up. But we became involved in the spring of 2016, and after we weren't able to get any, we tried to negotiate with the other parties, and we tried to get a conversation going, but we really didn't get any answer. And I ended up sending a demand letter to the developers and never got an answer either. So we finally filed a complaint in federal district court in the Western Massachusetts division in Springfield, out of desperation, because it looked very much like the suspected burial ground and the known CSLs that go with them were going to be destroyed without any consideration.
Cachat?
Yes.
Let's talk about the legal aspect of what's happening.
Okay. What's happening here in Shutesbury is a similar situation to what's happening in a lot of places in the state and across the country. And our situation here involves specifically Massachusetts laws as well as federal laws, and that's one of the situations we have in the United States. We don't have a full set of federal laws that govern all aspects of Native American rights and issues. It's shared between the federal government, the state governments, and the local governments, which makes it complicated for Indigenous people because they have to address their legal issues on all three tiers. So what's happening here in Shutesbury, it's a good window to look in at these situations, because it does offer most of the issues that come to play in this. So what we have here is a piece of land that was transferred in what's referred to as the Indian land deeds for, I think it was Hampshire County. I forget which was first, but the one county originally included all of what is now Hampden, Franklin, and Berkshire counties as well. It was all of western Massachusetts was one county at that time. And it was sort of made up out of thin air, because at the time that the county was officially formed out of the Boston General Courts, there were all of about 4 fledgling little colonial towns in the entire western Massachusetts. So in those land deeds, the Sachem who signed the deeds reserved rights for certain areas of the land, and part of those rights that they reserved was in the wooded areas that they had deeded, because part of the, and it's not clear, I should back up and say that, you know, from the colonial point of view, these were deeds, but nowhere in the deeds is it made clear that the legal nature of these documents was explained, or, you know, what we call legally disclosed to the signatory parties. So there, in any contract, there's a thing called full legal disclosure, a disclosure or a statement of facts that meets the legal requirement for being a fair contract. If you hide elements or don't mention or don't appropriately discuss elements of a contract that are important to that contract, have significant impact on it, then that's not a legal contract. And so part of the problem with these deeds is that there's no evidence that any of the Indigenous people who signed these deeds could read English. There is evidence that they spoke English, and conversely, on the other end, there's no evidence that the colonial people who made the deeds with them spoke their language at all. So there's a two-way language barrier in that the native people could not read the contract that they were signing, and the English people who were trying to make this contract with them could not explain it to them in their language. So we have a situation where there's only one language in a bilingual political interaction. There's only one language carrying the entire interaction, and half the participants can't read in that language, so they cannot read the document. It's sort of like being in a situation where the opposing party's lawyers are reading you the contract, and that's all you get to know. It's not a trustworthy situation. There's this second problem with these quote-unquote deeds, is that the evidence of Algonquian traditions culturally, which is very much evidenced by people like Dr. Bruchik and Mr. Ruttenberg, who wrote histories of the native people in the Hudson's Valley, and a lot of colonial documents and commentaries on frustrations dealing between colonial people and indigenous people. There was a lot of frustration amongst the colonial people that and they noted this very often, that the indigenous people didn't have a truly centralized government, that their alliances and their loyalties were sort of fluid and somewhat shifting. And that was actually used as a tool to attack their rights to land tenure. But conversely, it also attacks the right of colonial people to select an individual or a small group of individuals at their choice, and then declare those people the absolute, or autocrats or absolute representatives of those people. The situation as documented and as discussed by people like Dr. Bruchik is the opposite. All the evidence points that culturally, and actually Wassenaar and other early Dutch recorders and other early English recorders testified in their statements about this historically, that they call these societies democracies. Actually, Wassenaar called them the truest of democracies, because they said that even though sachems and different forms of rulers were hereditary, they only could exercise their power through the respect of the people who supported them. And it was only by their wisdom and their abilities that they could get that support. So people were free to actually shift their loyalty to a different leader if they felt the current leader was unsatisfactory. And Ruttenberg notes from his colonial sources that people were known to rise from what they call the common ranks. Not that there's evidence that society was stratified in that way for them to positions of leadership, and there are a bunch of documented cases of that. So here we have a dual problem, is that we're in these supposed deeds, we don't have disclosure, we don't have communication in languages that both parties can understand and read in, and we don't have a cultural political situation on the part of the Algonquians where any one or two or even a handful of people have any kind of absolute power. And beneath that is the second layer of cultural taboo, in that, which I'll get to in more detail further on, but there were different kinds of land management regimes applied. And the people of this region of the Connecticut Valley, and in fact, the whole Algonquian region of the eastern seaboard, had very firm ideas about allotment of land for planting, which in the local language here in Nipmuc is called Kuntanakish or Kuntanakil, which means, it comes from Kutaham, which means he plants, and it's a planting land, a plantation. Then there's the areas where villages were located, and then separately there's what they call Tawakamuk. Tawakamuk is the Dawan are open and free, unallottable communal lands that carry a lot of taboos because these are sacred lands. And I've just completed a report on this. I've done some research, and I'm submitting it almost as we speak to the Massachusetts Archaeological Society for their bulletin. Hopefully it will be published in the spring issue of this year, that discusses this issue in detail, that goes through the terminology, the legal documents and the historical documents, and examines land management and native quote-unquote laws about land management. So the long and short of it is that under no circumstances did any leader of any tribal group have the right to sign away sacred lands, to sign away lands that were held in common. And in fact, all the evidence is that tribes actually shared these lands to a great degree mutually. These were where the powwows, the gatherings were held. And you have in many places records that report many nations coming together in these sacred places, which were ideal for coming together because they weren't allotted individual clan lands, they're communal lands where you can host other nations that from the region or your neighbors. And frequently, actually, these lands are along the boundaries between nations, which gives a convenient space buffer and ecological buffer between nations that helps lower competition, helps lower friction between nations, and is a physical place where they can meet and sort of firm up their good relations. So it sort of helps avoid bad relations, helps firm up good relations.
Like a diplomatic, neutral land.
Absolutely, yeah. And this is a theme that I think many people who are well versed in a specific nation can attest to for those nations, that you find in the Western Hemisphere a great deal of this sort of sense of neutral zones that they aren't the kind of lands that anybody can sign away. Now conversely, when it comes to planting lands and lands where villages are located, these in the same documents are leased out rather freely, possibly for the obvious reason that after a genocide swept through this valley, the planting lands were, tragically largely empty. There weren't people there to farm them anymore, and many of the village sites were completely empty because the people in them had been massacred, or 80 to 90% of them died from influenza and a variety of other introduced diseases, which were not accidentally introduced too. Local people like Amherst actually designed a campaign of handing out infected blankets in order to, rid the land of this execrable race. So he wasn't mincing words about his genocidal plans. But the result was that there are all these empty village sites, there are all these empty plantation lands, and therefore it's very easy to agree to lease these lands. And not only that, but when you're facing huge land pressure and getting attacked for your land, and you have no population base now to defend your lands from people who are invading them, it sort of puts the people who are indigenous in a position of having really only one kind of choice in order to diffuse the situation, which is to agree to give land to whatever extent you can manage to agree to that in order to diffuse the genocide that's happening to you. And this is a dynamic we sadly see over and over again if we look through world history about human conflicts and genocides. So the end result is that we inherit a legal situation which is fraught with fraudulent bases, it's fraught with cultural conflicts and misunderstandings, and it's also fraught with an agenda of hegemony and imperialism that really cannot be ignored in this discussion. And unfortunately, this hegemony continues to this day, because now we have a legal structure in this country where the federal government will intercede only inside the space of the current assigned federal reservation territory.
And I want to ask, we were talking about these neutral lands. Since they are neutral, I imagine that it's very hard for example, a nation to claim it under their reservation land. So it's a lot of times like outside of the power of the protection of, a federal recognition.
Well, as it happens early on, the colonial people who interacted with most of the native groups here seem to have initially recognized their sacred lands, like the Badlands in the Dakotas and stuff, were initially given some recognition especially by missionaries who tended to be a little bit more culturally sensitive, even though in the end they were very culturally destructive. Their agenda was ostensibly spiritual, and because of that, more given to listening and understanding a little more. But over time, you're right in saying that these did not end up receiving federal protection, because what happened was, and this is the Lakota are a wonderful example, also because they have some of the best delineated treaties and some of the most stark treaty interactions. They provide a really good lens for this. So early on, when colonial people are trying to construct a safe passage through the continent to reach the Pacific shore, which they wish to colonize, and they're trying to accomplish what they call manifest destiny, which was, they considered it their manifest right to just basically overthrow other races and take over all the land. The trail out towards Oregon and the western coast passed through Lakota land, and as people began to invade their land, the Lakota defended their land, and there was immediate violent interaction, and the armies sought to diffuse that by making a treaty with them. They also wanted to make a chain of forts along the trail. So what happened was they signed a series of treaties very quickly after the Civil War that granted the Lakota and their near relatives almost thought more than all of what is now North and South Dakota and parts of the neighboring states. These treaties were congressionally ratified, so they carry all the weight of that an international treaty should carry with Britain or France or any other country. They very quickly violated these treaties by building forts outside of the area that they were permitted to build forts, and war broke out again. The Lakota quickly got the upper hand in both of these wars. I have a book in the upper room about the military policy of the United States regarding Native Americans, and it's a pretty good work because it explains like how the military policy worked to keep continual conflict going, because the policy itself was victim of changing attitudes that the country waffled back and forth between committing genocide and being embarrassed by it for about 300 years. And so there was this aggression and pullback, aggression and pullback, and aggression and pullback. And for the indigenous people, it was equally confusing because they were being attacked, made promises of peace. They took, as James, I think his first name is James, Mr. Wood from England noted in Plymouth Colony, and I try to get this quote right, he said that every Native person, I have to paraphrase, every Native person is good for their word because they value nothing else about a person more heavily. A person who's not good for the word had no value in their society. So it's not possible to go back on your word. Nobody will deal with you after that. This isn't the paradigm that the imperial powers are bringing with them. So they were confused by these treaties that were ratified, and the history is full of these lengthy complaints from chiefs about violations of treaties and then trust they invested in them, without a lot of response on the other end. So what happened was a series of conflicts with the Lakota that were generated by treaties that were then quickly broken, and the federal government continually shrunk the land that they ceded to them, which is a strange way to say it because it was their land. Some people showed up, they said we own all of it, and then they said, well, we'll give you part of it back. It was a very strange paradigm to speak within, but that's from the European point of view. That's how it went. And in that process, the federal government actually said nobody can go into the Badlands. They recognized its sacredness, and they recognized the provocation that colonial squatters entering those lands was causing. Several bloody conflicts were generated by squatters going into the Badlands and violating the sacredness of it. And they recognized, they called gold the metal that makes white men crazy. And so they recognized the danger that once gold was suspected or discovered, what would happen to that land. And sure enough, despite the federal ban, George Custer decided to lead a party of civilians and other people into the Badlands. They found gold, and there was an immediate rush, which the government could not or chose not to stem.
And this isn't even a historical problem, but it's even a current problem in the
Absolutely.
sense that I believe the Black Hills,
Yes.
which were promised reservation land, right now are being excavated for gold.
Absolutely, it's a conflict that hasn't ended since that point, and has had recurring violence because of that conflict. When I said Badlands, I mean the Black Hills, and including area beyond that to some extent, which I understand that my understanding is that some areas beyond that are also part of this sacred zone. But in any case, I could be wrong about that. But that's what happened. Custer went in. They immediately started tearing the Black Hills apart. And of course, there's also uranium. These hills are exposed under layers of a lot of rare earth minerals or uncommon minerals. And so now uranium is another issue. There's actually a native study of the Badlands going on now and the Black Hills, where they're trying to map out uranium zones and discover the source of baseline uranium contamination that's happening in the area that they can't pinpoint, but which has a prophetic basis in Lakota society about when they rape the earth like this, that it would poison the people. But in any case, so that led to a legal debacle in which the federal government just decided to seize the Black Hills. It was part of the treaty land, and of course Standing Rock is part of the treaty land, and in fact all of North and South Dakota and large parts of the neighboring states are part of a congressionally ratified treaty, and most of that was subsequently re-treated to them again, and ignored. And they stole it, they excised it from the reservation, they shrunk the reservation down, and then there were two acts that came in the late 1800s and the early 1900s that further shrank reservation lands, or land that's actually in tenure of indigenous people. The Dawes Act and the Allotment Acts, if I got the names right. But it's two acts that basically took the communal basis of land ownership and assigned post-genocide populations that were at historic lows around the turn of the 1900s, and reassigned individual lots to the surviving people, which they would then have to subdivide forever from generation to generation. They took all what they called the excess land, and they gave very small pieces of land and then gave that away to European Americans to settle. So by these processes, they basically stole back almost all of the land that was given by treaties and reduced now to what we see today on maps as these little pieces of reservations. And that's currently the only land the federal government will defend native rights on, are those reservation pieces of what was originally a vast treaty land.
And I believe that, for example, there's also the federal government has tried to buy a lot of the land that was taken under, for example, the Black Hills. There's I know there's a campaign, the Black Hills are not for sale, because the federal government attempted.
They but they offered a settlement.
Yes, a settlement.
I think it's the longest standing court case in U.S. history by the Lakota, Dakota, Nakota peoples, but primarily I think it's the Lakota's case. And you're completely correct. They sort of forced a purchase on them, in the sense that at a certain point, I think it was in the Dawes Act, the federal, or actually quite earlier than that, now I think, the federal government just sort of unilaterally decided that the government is now overseers of the indigenous people, and that all the indigenous people are wards of the government. They did this in Canada too. They did this more literally in Canada. They assigned them as wards of the government on the basis that they were basically racially incompetent. It's a horrifying sort of discussion, but that is the basis that they did that on. And it comes out of this sort of eugenics and Nazistic sort of swell of point of view that was coming from interplay between the United States and Europe, because eugenics actually originated in the United States, then was shipped to Europe by the Rockefeller family in the form of a bunch of professors they sent to Germany, where it became popular in England and Germany, and then shipped back to America. And Hitler famously quoted a study here in Shutesbury that regarded some people as genetically incompetent, and that became a basis for sterilizing people of color, people with mental issues, people who suffered retardation as a birth accident, which doesn't have a genetic basis, so it's not even valid scientifically on any level. But they forced the sale of the Black Hills on these people on the basis that they had unilaterally been declared wards of the Bureau of Indian Affairs. Previous to 1920-something, Native Americans didn't enjoy citizenship, but then a further act gave them citizenship, which was a double-edged sword, because it confers some rights, but then it steals other rights away. Now it steals your sovereignty away, utterly, for one thing. The Lakota never accepted this settlement.
Yeah, I believe it's still, like still there and never touched.
So legally speaking, a plaintiff has to accept a settlement. So this is a bizarre case where the federal government and the Department of Justice is sort of standing on an illegality where they're saying, despite that you don't accept the settlement, we're declaring the case closed and the settlement valid, but it doesn't hold under one of the fundamental bases of law, which is that in any court situation, the settlement has to be agreed upon. So we have this bizarre separation in law when it comes to people of color and in Euro-American people and how law is executed. You don't find cases of Euro-Americans being forced to accept settlements except for when the government declares eminent domain. But I don't believe eminent domain was declared in the Black Hills case in the time frame in which it was actually stolen from them. Though it may be an argument that was leveraged 80 years later in court, it wasn't on the ground at the time.
Yeah, we can also see, for example, how the federal government treats Native Americans and First Nations when compared to how they treat, for example, like the Bundys, who took federal land with guns, with violence, and then, for example, how the Cachat and the water protectors are being treated right now.
Stark.
Yeah, when they aren't having any weapons or any violence and just peacefully protesting.
Yeah, it's really very stark. I'm glad you brought that up. It's a hurtful issue, but it's hard one to avoid. It does rather seem that when people of European descent get angry at their government and make an action that they and there are a lot of militias in this country, and they're almost all not to be racist about it, but they're almost all white militias, and a lot of them have dogmas behind that are essentially white supremacists, if not explicitly white supremacist, or if not in effect white supremacist. And the Bundy case is a white supremacist situation in effect and in its base dogma, in that they're standing on indigenous land, ignoring the indigenous rights to that land. They're usurping federal law, and they're saying that they're basically saying when a minority of European people in a situation aren't happy with the law, that we don't have to obey it. That law exists for indigenous people and people of color and other people, but if you're Anglo-American and you can trace your heritage back, 5, 6, 7, 8 generations, which people in this country, lay out as some kind of remarkable legacy. But you understand that only goes a couple hundred years before people who've been there for 10,000 years. There is this sort of social paradigm that has existed from the start up to now, that a very small group of a couple hundred, a couple of thousand, or even a few dozen European Americans can stand down the government and if they give it a political basis, be given cush treatment and be dealt with in the most gentle terms by the government, who then try to appease them. They don't represent a population majority, and they don't represent a political majority. In fact, the whole middle of the country represents a population and political, serious minority. But they're given, very disproportionate weight. Anything they want, and the government is given disproportionate weight. And even the federal government actually sort of deprived the entire East Coast of a lot of infrastructure support in order to invest in the West and the Midwest, in these huge dam projects and whatnot that are not paralleled in the East, which created Western agriculture, which created Western economy. And the strength of Western economy is based on federal projects where the federal government went in, seized indigenous land, put up dams, and created irrigation for European Americans who were then invited in to homestead and quote-unquote settle land that had been settled for 10, 15, 20,000 years previously, almost for free. And we then declare ownership of those water rights, and then when native people downriver want water, they say they're stealing our water. So it's this closed discussion that never lets another truth enter in. But any number of Native Americans can stand on the other side and point to treaties and this, that, and the other, and if they don't step out of the way, they won't be given, and historically never have really, any truck with the government or by the government, and if they don't get out of the way, they very much stand to be shot. And Wounded Knee, having happened in modern times, is a demonstration of exactly that. And in fact, Leonard Peltier remains in prison to this day, even though the evidence is that and they confessed that 2 teenage boys did the shooting. It was the political leader of that group who got put in jail forever. So that tells you a lot about this. In fact, when you look through colonial records right up to modern times, even murder of indigenous people is not investigated or prosecuted. And Canada has the same problem. You can read currently about 1,200 women missing in Canada whose cases have never been, they're all murder victims, but their cases have not been pursued. And these are modern cases. And you can see the same dynamic on almost any reservation you go to, that Native Americans are the only racial group tracked by the federal government who are murdered by people outside the race, in the majority. The unhappy reality of it is that people tend to commit violence mostly against people within their own racial group as they identify themselves. That tells you something. And in no colonial record that I've ever heard of, and I've read quite a bit on this, was any European person ever convicted of murdering a native person, although these murders were pretty frequent and or alarmingly frequent. And Lincoln himself hung 20 some odd Dakota men for violence that they had not committed, that was actually committed by another tribal group who themselves had endured violence. This all was happening in Minnesota and Wisconsin, which sparked violence that basically evicted the Dakota and Nakota people from their lands largely in those states. Started out with a small incident, but Lincoln's actual solution, right after he emancipated the slaves, he said, let them hang. The whole 20 some odd, I think it's 27 men, and they were given the briefest trial I think I've ever, I can't remember exactly how long it lasted, I think it was something like 20 minutes for the whole lot of them. As I said, they weren't even the perpetrators, but any Injun will do when taking revenge, and that is the paradigm. The Sand Creek Massacre was committed against the wrong tribe. There's a tribe with which we had a treaty and who were on peaceful relations with us, and they were trying to get revenge on 2 boys who killed a cow. So they killed like 300 men, women, and children of another tribe. So the imbalance of law is ridiculous. It's the only way to say it. It's an absurdity.
Yeah, I believe that studies show that Native Americans are the biggest racial group that are killed by police, more than African Americans, more than Latinos, and they have been mostly ignored because a lot of times there's a lot of, also for example in cases of rape, that if it happens on reservation land and it's not a person of Native American descent and it's a white person, there's like a legal loophole almost where they do not get charged, right?
Well, it's the FBI should really take care of it because it's a cross-border situation. If you cross into another state, it becomes an FBI affair because now it's outside. It involves more than just the state jurisdiction, but it becomes easy to ignore, and that's happening outside of violence. When it comes to land tenure, the same problem is occurring. Which brings us back to home and situations, but it's the same situation at Standing Rock. That is happening right here. In Massachusetts, ostensibly, we have, well, first of all, we have the Federal Bureau of Interior Section 106 rules, which are working rules for dealing with historical and archaeological properties on federal lands. But it also applies, according to the rules, Section 106 and federal jurisdiction are triggered whenever there is any undertaking that involves a permit or application to or from any government agency. Since Standing Rock project and the project proposal in Shutesbury both require an EPA approval, that triggers federal jurisdiction because it is now officially an undertaking because it qualifies as an undertaking in the legal mumbo jumbo. It qualifies as an undertaking because the EPA is a federal agency. The EPA must they must apply to the EPA. Once you have to apply to the EPA, you've brought in federal jurisdiction. It's that simple. They argue this to death, up and down, to avoid that reality, but that is the reality of it. So what is happening here is that they've been simply circumventing that. They circumvent it because Section 106 requires that tribal historic preservation officers be brought in, or their delegates, to survey and inspect any property that's claimed by a tribe as their cultural legacy, what they call traditional cultural properties, and which includes ceremonial stone landscapes. And in order to avoid allowing the tribes onto land, people who want to use land without that inspection have come up with creative ways to circumvent that. And one way is by delaying an EPA application. Another way is by hiring and paying a lot of money to lawyers to drag it out in court till the other party runs out of money, or to just crush them in court through their influence.
And I believe
but
it's not always
based in law.
And it's not always private lawyers. For example, the attorney who was just put in charge of the EPA has been somebody that has been fighting on the side of the oil companies and oil corporations against the EPA.
Absolutely, it's an individual who's made strident public statements against the EPA, invalidating the purpose of the EPA altogether. And in the situation here in Massachusetts, we further have Massachusetts General Law 114, I believe, Section 17, 18, 45, and other sections, if I've gotten those right. MGL 114 is the basic law, and that's the law that deals with burials, cemeteries, and things connected to that, mortuary practices. And in that law, it says that what they call American Indian, which is weird, because people from the Indian subcontinent would be Indian Americans, so it's kind of confusing terminology. But by that they mean First Nations, Indigenous people. Any place suspected to contain the remains of one or more American Indians qualifies as a suspected burial ground. There's no further qualification about who can make that declaration or what that's based on, but just the plain English word suspected is the only qualification. That means without further qualification, that gives the right of anybody to suspect such a thing. But without, carrying that too far, even just being stricter about the people with direct knowledge, the law then says that such a place is inalienable for any other purpose. But that law is then undermined by a subsequent section of the law, which was a legal deal between interested parties in the state government and just one federally recognized tribe in the state out of the several tribes who have fought for recognition, and some have won federal recognition only to have it taken away shortly thereafter, which is another bizarre sort of ridiculous reality, absurdist reality to live in, where at one point the government's saying to you, you're a valid sovereign people, and then decides 2 years later, no, you're not. So how a government can contradict itself but still, hold its head forward, its face forward in public and say we have dignity and we have integrity, and we have veracity, when you can say we find you legitimate and sovereign, and then turn around and say we don't. You're creating a self-contradiction as a government that really needs to be resolved, and they don't attempt to resolve. They just simply say that your documents are legitimate today, and 2 years later they're not legitimate. And it was a regime change. It was a change in presidents that affected that change. So it's subject to the vagaries of political whims, which is not really something that people's rights and land tenure should be subject to, especially when they're already protected under treaties. So the bizarre circumstance has arisen that there are laws that appear to protect Native American burial sites, but in effect, on the ground, nothing happens. And a case that highlights that, other than the case we currently have in Shutesbury, is a case just across the river in a place called Wissatinawag, which means glistening hill because it's by the falls and it's a basalt promontory and glistens with the spray of the falls. It served several villages nearby. It goes back somewhere around 10,000 or more years. It's a archaeologically ultra significant location. There's probably 25 or less sites of that age known in New England, and so maybe there are more at this point, but it's hugely significant, and the fact that it happens to be a really ancient cemetery is massively significant, and the fact that it was induced right up to the times of the genocide and through into historical times makes it almost singularly significant. Excuse me, but nevertheless, it was given no protection by the state. The state at no point did the historical preservation efforts of the state include an effort to purchase that space. It's documented since colonial times. There was a massacre that occurred at Peskamsket just across the river from there during a sacred religious festival that killed over 300 women and children. And this cemetery actually probably held the bodies of some of those victims. But what happened was, without any attempt to protect or purchase or in any way confer any kind of continuity to that space, it was actually dug up to provide fill for an extension on Route 2, just past the French King Bridge in Greenfield, as a matter of convenience, because it was a sandy deposit. And George Nelson, who is a local avocational archaeologist, witnessed the disinterment of human beings in large numbers, and they're being dumped into a landfill for a highway, and went to court in 1964, I believe, and made a court deposition about this. Now, according to law, work has to stop. There has to be an archaeological survey, and the bodies have to be properly reinterred, and tribal rights have to be conferred on this, consulted on this, and respected. What actually happened was that George Nelson made himself the sole individual protector of this place and campaigned in every way he could to protect it. Nonetheless, it was about 80% destroyed. And from 1964 to 1996, I think it was, I'm not sure exactly, or 99, there was no point at which the state interceded to stop this destruction, even though it violates a number of laws. And the state had a number of duties to perform that it did not perform. And when George Nelson was asked in court as to why he thought that nothing was ever done, he said that he felt his opinion, and he lived in the area from almost all of his life, his opinion as a local resident was that nobody wanted to be responsible for stopping what was a popular project. And the other side of the coin is there were no, or insufficient Indigenous voice in the situation for anybody to care. And there was no regard for Indigenous rights in that situation. So what happened was, he gave a full skeleton of a woman in her early 20s to the University of Massachusetts at Amherst, named for a genocide planner, actually, ironically. And having received this property, the University of Massachusetts is owned by the state of Massachusetts, and having received this property, they have a bunch of legal obligations to perform under the law, none of which were performed. They received the skeleton. The Massachusetts Historical Commission did nothing. The university did nothing. The state, the Secretary of the Commonwealth did nothing, and the destruction just continued. Then finally, after 1999 and going forward, a private group of Indigenous and non-Indigenous citizens came together, and they eventually called themselves Friends of Wissatinawag, and they collected the money, and they did the legal work, and they got the advisement to try to confer some legal protection and to purchase the property And it wasn't until uh, 2012 that the property, I think that the whole deal went through. The property is finally purchased. The state got 21 acres of free DCR property out of the deal, so the state got their palm greased and got a nice gift out of that. And the cemetery nonetheless remains about 80% destroyed, and the remnant was then, reconsecrated through the efforts of these people and the tribes that they got involved to help them. And then out of that arose the Nolumbico project, which is again another private effort of private citizens and private donations to try to. They actually got a law passed in Greenfield after some attempts that did confer protection to native sites going forward. And they've been working to raise awareness and get people together behind this. And the doubly ironic thing that arises out of this situation that tells so much about the legal and cultural context of what's going on here is that just across from Wisatinawag, as I mentioned, was a massacre site called Peskamska, which means, so it's often translated as place of the split rock, but Pesque actually means like a twin or pair or something. And Peskamska is on top of the twin rocks. It's a village near the twin rocks, which I believe is describing the Great Falls, or a stream that goes over from a sacred site into what we now call Barton's Cove, which is actually called Montehalis, another sacred site. So sacred sites all around. And just to the east of this, it's still in the town of Montague. There's a site that's now called Sacred Hill Ceremonial Site. And this site in, I think it was 2008, December 11th of 2008, was actually conferred National Registry of Historic Places designation as a traditional cultural property and a ceremonial stone landscape. It's the first federally recognized NRHP property that is a ceremonial stone landscape east of the Mississippi. And subsequently there's been a second one in Buzzards Bay, which is between the Cape and the mainland in southeast Massachusetts. That's actually underwater, that was originally sat on the coastal plain, which became flooded after the last glacial melt-off, starting about 12,000 years ago and continuing to about 10,000, 9,000 years ago. The sea level rose quite a bit, and the Narragansett had a standing tradition that the people hunted that land, which would have been a nice sort of savanna along the coast and would have been great for grazing animals. And their traditional history is actually confirmed now by archaeology, where they discovered these ceremonial stone landscapes that are now flooded by the sea level rise. And so who knows how much of archaeology in the world sits under the water. Probably quite a bit, and probably a lot of the mysteries of the world could be solved by what lays under the water since the last glacial melt-off. But in any case, that site goes back quite a ways too. It involves a number of stone structures like we have in Shutesbury here. And when they declared that Traditional Cultural Properties District, the NRHP included a radius that engulfs most of Franklin County, going about 16 miles out from there, which fully includes the town of Shutesbury as an overall traditional cultural properties district, because this whole region was a sort of an unusually sacred space. It contained a number of very significant sacred sites, most especially Great Falls and the Sacred Hills Ceremonial Site, but hundreds of other sites as satellites around it in what was a sacred ceremonial landscape of special value, not just to the Pocumtuck over by what is now Deerfield, and not just to the Nashwe Nipmuc who lived over here, or the Warnock or the Norwottuck or other tribal divisions, but also the Sokoke Abenaki to the north of us, and the Piscataway Abenaki to the northeast, and the tribes in the entire region who are recorded to have convened at such places. And there's places in the Hudson Valley that are equivalent to this place called Danskamer, and another place also called Danskamer, which is Dutch for dancing room, at what is now called Rolf Jansenkill, which is near Claverack, New York. and the other location, Dunscomber, trying to remember what town that's near, but it's south of the Esopus region on the Hudson River. Another location in the region where we have a parallel set of locations or district that was ceremonial, that tribes from a large area would come in to meet, and in fact were recorded by the Dutch to do that. So this town sits in a ceremonial landscape, much like the Black Hills. It's not just a hill or one spot that's sacred, it's the whole place. And this whole place is sacred, the hill areas of this whole place. So the legal situation here is such that the owners of the lot don't want to recognize the covenant reserving access rights by Native Americans, which is delineated in folios 33 through 39, or I'm sorry, 33 through 37 of the quote-unquote Indian Land Deed Archives for this county, where they made a bunch of specific reserved rights to enter and carry on their traditional activities that were actually separately stated out in separate clauses. It was that important that they got back to, after the main document's done, they said, but we want these reserved rights. And it was separately signed off. They want to ignore that. They also don't want to allow tribal authorities to come in and review the land to see if they want to confirm or disconfirm the presence of a suspected burial ground and ceremonial stone landscape there. And they also don't want to allow any other parties in with that kind of knowledge to engage in a discussion. They don't want anybody who has cultural concerns to examine the land. So what they instead did was hire their own survey. The survey was very superficial. They did not, they only looked at 26 out of at least 40 or more reported mounds. They only looked at a couple of stone objects, and they didn't bring in anybody who has cultural ties to the people who live here, has linguistic ties or ethnic ties. In other words, the people who examine the ground don't speak the language, don't know the religion, and really don't have any, as far as I know, they have absolutely no training of any kind to be able to interpret cultural properties. They're archaeologists whose training is, in general, in these cases, solely around looking at physical objects and doing standard analyses according to their dogma, their paradigms. But they have, to my knowledge, absolutely no basis of knowledge in which they could possibly look at an object and understand whether it is in fact a cultural item or not a cultural item when it pertains to religion. The other problem is that a genocide occurred in this valley, and nobody in academia can answer a very simple question. Where were the people who died in this genocide buried? This is actually a question that was posed in an open town meeting to the archaeologist who was the reviewer for the town of the latest attempt to bolster the original survey. They wrote a second report that doesn't involve any new survey or any new data or any new analyses, but just sort of fluffs up the original report. Quite literally, it actually states in the beginning of the report that the purpose of the report is to support the original report. Doesn't even claim to be a re-examination or a second survey. So we have a dilemma here in that the traditional cultural properties issue and all the legal claims attached to that are being suppressed in this case and ignored. And they're basically trying to push the project through without addressing that. And the contention on our side is that there are legal reasons why, and certainly moral reasons why, these issues should be addressed. And in fact, the town's own counselor, the town's own attorney said in a select board meeting that the town has a moral obligation above and beyond the law to responsibly determine if human beings are buried there. to which I completely agree, and I think almost any civilized human being would. It's also an international crime to violate burials and to destroy traditional cultural properties. And the International Court actually handed down their first conviction concerning a case in Mali of exactly that, in which a stone structure was attacked and violated by a person with desecration intent. And so it sets a international precedent for this.
And has construction started on that land, or is it yet to...
No, it hasn't. It's been since June that they got their initial approval, but the initial approval wasn't. They didn't get the permit fully because they wanted them to do a traditional cultural properties survey, and there were several other issues which they needed to address. And out of that came a checklist of items of function or actions that the developers and the owners need to perform if they want to get that permit. One of which was to accomplish a traditional cultural property survey. That hasn't been performed. And in the last meeting, we actually found out that there's a series of actions that they have not yet performed. And when they appeared in court in our last hearing, the attorneys for the developer and the owners and the town said that they are not ready to go forward. They're not ready to break ground. They don't know when they're going to be ready. And in fact, they couldn't even supply even a vague time frame for being ready. The judge asked them if they would be ready in a week, a month, a year, and they said, we can't even say.
And you have been personally involved in this case. Could you please tell us your reason for your involvement and what has happened personally?
Yeah, sure, I can. How far back to go with this? I first personally became involved in Indigenous rights as a child in grade school when I can't remember clearly the situation, but I got in big trouble because a teacher was reciting a mythical statement about Native Americans that I knew to be untrue because I had read it from primary source documents in our library, and I had been told differently by my own family. So I made a rather vocal objection to that and got sent to the principal, and that was the start of it. I was punished for that, and I was punished actually many times in school for making corrective statements about statements that were being made by teachers that were factually incorrect and provably incorrect, and I got punished every time. So I found out early on that it's not rewarded to stand up for Indigenous rights, and then we came to this situation, and I became interested as a teenager when I learned more about my family, and I really invested some time in learning about Indigenous culture, and I invested some time learning about herbal medicine, ethnobotany, and I found mentors to tutor me and teach me, and then when we moved here, we found that there were sacred relics in the yard where we lived. And I was really shocked to discover this. And I knew there were sacred relics in this town, and during my childhood we had visited a bunch of times, and as I got older I visited more into this area to visit sacred sites. But I wasn't fully aware of how many there were in this town. The focus of my pilgrimages had been Kumquatchu, which is a healing place of great sacredness that they call Nantobi Massif. But as we lived in town, we began to recognize how concentrated this particular town is with sacred stone relics, and that fit into the fact that the town was sort of a lonely piece of land between more heavily populated valley areas and the primary kind of land that would be selected for a sacred site. And not only that, but it's a piece of land that is very replete with natural springs and other features that also lend it high value in practical terms, but also in sacred terms. So we went on a 3-year project where we studied all the sites in the area, in this town. And we talked to people who had been doing this as well for many years, and local tribes, to try to, first of all, share information, but get insight from them, and give each other insight and context, and also to find out what people already knew that we didn't have to report, and to try to fill in what hadn't been reported. As I went through these sites, I noticed a lot of early damage, a lot of damage that had been healed over with lichen over time and stuff like that. But I also noticed a lot of modern damage, a lot of very recent damage, where people were sort of making a hobby out of taking stone relics apart and rearranging them into their own modern expressions of sculpture, which is alarming because a lot of these are on public lands, and it's against the law to tamper with minerals and plants on DCR land. But again, I sent 1,000 protestations to the DCR, to their historical properties manager, Patrice Quiche, and to archaeologists for the DCR, and to DCR legal people, and got almost no response. I got a response from one archaeologist, but from nobody else. We protested to the town, we protested to, since 1993 or something, I've been writing letters to the state historical commission and governors and people in the legislature without any responses, or with very brush-off responses. In one or two cases, I got one or two answers from representatives who basically, they literally brushed me off to interns who were there for the summer, who gave me information that was appropriate for school children, and didn't really address any of the issues. Then I realized I needed to get personally involved. So I started to try to talk to the town here, town government, about preservation issues, and in the midst of entering into that discussion, I stumbled into a situation attending a Conservation Commission meeting where I suddenly discovered that there was a solar project being proposed here on a piece of land that was in the midst of a pilgrimage route that I've been taking, where I personally knew there were a lot of sacred sites. Then I looked more closely at where this project was being located, and it became even more alarming to me. Then I talked to other people in the area and got information from them that became more alarming, and we went and we took a detailed look, and we found what very much appeared to be clusters of graves that matched descriptions of other graves, and in fact matched the graves that I have witnessed myself. And this was already within a ceremonial stone landscape, which further clues you into the possibility of burials. Although they aren't located in exactly the same places, they do have a locational relationship that is reliable. So when you find one, you can, over time, if you investigate enough, predict the existence of a burial ground and where it would be, which is fairly consistent. But then we also, on top of that, we have the genocide problem. And during genocides, anywhere in the world, if you look, you will discover that, to put it simply, people in desperation bury their people any which way they can, and often secretly, for fear of desecration of their bodies. It does happen in genocides that people attack the dead and mutilate their bodies, and it was happening to Native people. But also Native people at that point were very aware that every time the colonists gained knowledge of their burial grounds, they had witnessed this themselves already in colonial times, that they would immediately attack those places and dig them up for whatever treasures they could get out of them. And in fact, almost everything you see in museums that involves indigenous people are robbed graves. There's almost nothing in our museums that comes from between 1620 and 1950 that isn't somebody's grave that was dug out of the ground. And all of that is a desecration of the religion and culture of those peoples. So we knew the historical context. We knew that the state had not defended burial grounds. We knew that it was always been left up to a whistleblower, to cue in the tribes, or a dedicated avocational archaeologist to fight a lone campaign to stop destruction of burial grounds. It happened to the Wampanoag. In the Cape, they were told that a construction company dug up dug up a bunch of graves. They were lied to. The construction company said there were no graves there. Somebody told them differently. They were able to get an injunction to stop the construction. They were able to get in, look, and lo and behold, they found 26 or 27 full burials that were being dug up. So that's a very recent case. So that's the context of it. When we tried to talk about our concerns, what we got was a lot of pushback. We tried to talk about the legal obligations, moral obligations of the town, and while the town initially acknowledged the moral obligations, the planning board actually lobbied against us. They published statements, basically epistemic attacks on our religion and culture, basically saying we don't know our religion and culture, saying that we're wrong about what we think, and talking us down and even vilifying us, saying that we're bad people because we're standing in the way of what they want.
Do they do this in the courts, or do they do this like in a public way, like putting it in the newspaper?
On things like Nextdoor Shutesbury, which is a public blog forum where neighbors are supposed to talk politely to each other, in town meetings, in the newspapers. The lawyer for the developer, Michael Pill, went in the newspaper and said that we are making things up in regards to our religion and culture. They've been pretty vicious about it. And although the majority of the citizens in town support us, and we've gotten a lot of support, a number of citizens in town signed our petition. Over 2,000 people signed our second petition to the town, neither of which had any effect. I wrote an entire article and published it about the Shutesbury sites, I performed what I understand and what I've been told is, which is shocking to me. I had always, in my own stupidity, despite my early experiences and my knowledge, I had somehow, as a scientist, because I've been working in science for a long time, I had stupidly assumed that, of course, scientists would have looked at these objects and studied them and performed, objective, quantitative assessments of them to determine their origins. But what I found out was that the state had been relying on anecdotal evidence and racist assumptions that go back to colonial times, and that, to my knowledge, and as has been told to me, nobody actually had performed a direct observation study of sacred stone relics. Nobody had attempted to analyze their method of construction, their materials, and how they sit upon the land, how they relate to one another, how the individual relics relate to one another, how the sites relate to one another. They hadn't done any archaeology, to put it quite simply. This is how you do archaeology, right? Yes. And they hadn't taken the data even. They had gone in and done casual surveys, but they hadn't taken data. Or if they had taken data, they hadn't released any of it to the public. They haven't even discussed the fact that they have data. So what we simply did was we went in and we did the measurements. We collected the data. And we analyzed, we looked at what these objects are made out of, we looked at how they're made, what the materials are, how the materials class together, how the objects class.
Do you remember the results of your study?
Yeah, and it's still available through the Massachusetts Archaeological Society in their bulletin. And the results are that we found not to get into too many of the numbers, but we found really stark consistency. We looked at over 60 sites. We looked at over 750 individual stone relics. They class into about 4 to 6 major kinds of relics, and they have different ceremonial functions, which is a detailed story in itself. And that in the end is the most important story, is their ceremonial functions. And that in the end is the crux of why I'm in this personally, because we worship there. Mm-hmm. And I had been for most of my adult life. And even when I was a teen, me and my hippie friends used to gather at ceremonial stone relic spaces in Pound Ridge and Westchester where we lived. And we would hang out in the woods and quote-unquote reverence them, which is a very new agey, hippie kind of thing, but I think it's very culturally respectful. And even though most of the people gathered there were non-native people, and even though they mostly didn't have a whole lot of information, and probably almost none of them had any formal training in our ceremonies, they were all extremely respectful. And I think that's all that's required, really. They understood instinctively the nature of these relics to be ritual. They responded in a ritual heart, and they responded with love and respect. And it was just a thing we did as teenagers. We just did that. And we liked to hang out in the woods, and these teens just got this idea in their head, and they just did like that, which I think is kind of a beautiful thing. But that carried forward personally for me and for other people. We formed the Syncretic Spiritualist Church of the Northeast to address the issue that I always felt like I had to choose between being a Christian and being a native religionist. I looked at other religions. I tried to resolve this issue by going through a trajectory through the world of religion. I even became a Buddhist monk, and I was a devout Hindu. And I tried every religion. I tried to answer this dilemma by going from religion to religion, and all of which I hugely respect, all those religions, and all of which, you know, immensely enriched my life and me as a person, and led to 1,000 beautiful friendships, and and endless wonderful experiences. And I'm very grateful for all that was shared with me. And it led me right back around the circle where I found myself with my solution where I had started, which was that I just needed to put it together. I need to let these barriers come down and stop trying to be either a white person or a native person. And in fact, I'm trapped in a body where I am both European and native. So it's unresolvable for me, this conflict, except for to resolve the conflict entirely. So I don't really have a boundary in my mind between like who belongs at these sites. A person of respect who wants to offer a prayer is enough qualification for me. But we who go are largely native people, though some of us aren't, who are just as dedicated to going. And we make pilgrimages. In fact, I go out every morning to do prayers in Nipmuc and in Lenape, and I finish my day every day with prayers. And I pray before I go on any ventures, and I pray before I do any collection. My husband goes with me on almost a daily basis. We make pilgrimages to sacred sites. In fact, there is a sacred stone site right trapped in a thin piece of woods between our yard and Cowles over on the other side here. And I'm happy that they're under the protection of the wise people who own this property, who are really good-hearted people who respect these things, and they probably have survived to this point because of the respect that some people have decided to give them up to this point. But fortunately for them, they're fairly well hidden now by a thick layer of pine needles. But so it's personal for me. This is my religion. This is where my heart belongs. I plan to be buried with my husband in a traditional manner at the place where some of my family is buried in a traditional manner, where my children will hopefully be able to come and pray with us, and we hope to continue that legacy. But we can't if the pattern that is on the ground continues, because up to this point the state has almost entirely failed to enforce, and the federal government has almost entirely failed to enforce any situation to preserve a Native American burial ground or sacred site. Two sites that escaped execution that we named earlier, but we have, a dozen or more cases on the ground right now in Sandus Field and all over the place where forests that contain sacred relics are under the gun to be logged or have major development occur in them that would destroy sacred sites. And so what we're experiencing is like serial destruction of our places of worship. And that's why this case is in court, because at some point you need to draw the line on destruction of your places of worship before you have no place to go to worship. And Cowles has banned my family and all Native American people and a whole bunch of non-Native American citizens of this town from all of their land in Massachusetts, depriving me of hundreds of places of worship. That's sort of like as if a Catholic person or whatever Christian, Muslim or Jewish person was roaming in this country, and suddenly you were banned from, 60-70% of your houses of worship. And then as you approach a house of worship, you're suddenly obliged now to try to figure out whether this is a legal space for you or not. So you couldn't just walk into any place, house of worship. You'd have to check your list to see if you're banned from here or not.
Yeah, it'd be like a Catholic going to Vatican City and trying to figure out, okay, where can I go?
Yeah, what part of the Vatican can I visit? Yeah, what church am I allowed into? There's no labels on the churches saying you're banned from this church. Worse yet, though, it's a situation where those churches are getting leveled by the hundreds as you speak. In a situation where most of those churches would already be partly damaged. It would be only a handful of churches with no damage, and that the damage is several layers, and that is accelerating at this point. So it's an emergency situation because this half of the state was very thinly populated. Like I said, when the whole half of the state was one county at one point, which subsequently is now 5 counties, I believe, 4 or 5 counties, 4, I think. And in any case, there were only 4 towns when it was incorporated as such. And from like the 1630 up to about 1700, that only increased to like 7 towns. So there's almost somebody out here. It's almost sort of a bizarre clearing of the land of one people to set up emptiness. And then the state made and continues to make efforts to try to populate the area. They basically invited as one person called them, the never-do-wells of Boston, in a commentary, to kill Indians in trade for free land. That's how the homesteading was started out here. They were very much given incentives to move out. And even up into the 1960s, this area was very thinly populated. So a lot of the destruction that occurred eastward towards the coast was spared in what they call the hill towns just due to low land use. There wasn't enough of a population here to actually support complete clearing. They weren't able to really farm it. They just didn't have the labor force to do it. So that allows more sites to survive. But the big red flag now is that Franklin County is actually the fastest growing county in terms of development and population in the state, which means what had escaped destruction is now really under the gun. And that gives us our situation that we have today, where the rate of destruction is very rapid. The legal situation is one where the state has simply failed to enforce any rights of Native Americans.
Or any of its own laws.
Yeah, they simply skirt it. I mean, if they turn up people, they won't do anything until people are dug up. And the MGL laws, and in that case, by the way, they don't honor religion or righteousness in the sense that they do allow you to then be dug up and just redeposited elsewhere, which doesn't deal with the desecration factor, nor does it deal with what the land deeds say, that we have reserved rights to these lands. And not only that, but there are places that are named as reserved that also were not honored, that the land never actually was transferred. There's 20 acres or so around a place called Cachat out in Hadley and Amherst that was never deeded over, but nonetheless lost to us. It's actually our land, legally speaking, still. But in any case, that's part of it. And so there isn't any law supporting us. We're having to fight every single battle individually. Well, there is law that supports us, but it's not getting enforced. And the state is sort of dragging its feet in the opposite direction. Not only they're not out here trying to enforce and these laws and respect our rights, but they're actually sort of anchoring the Native community in the sense that they work against us. The head of the MHC refuses to acknowledge that Algonquin people worked in stone at all, which makes her sort of a lone wolf amongst the eastern seaboard states, in that almost all of the eastern seaboard states have embraced and acknowledged this. And even Timothy Ives, who's the state archaeologist in neighboring Rhode Island, has admitted, in a published article for the New England Anthropological Association, that he does acknowledge at least Wawanakosik as one form of truly native Algonquin ceremony and stone landscape. So while he still is well behind on understanding the breadth of our heritage and our relics, he at least has come forward enough to recognize one kind. Mm-hmm. Because it happens to be particularly noticeable and showy kind that's particularly well documented and involved a public ceremony that a lot of colonial people witnessed, but they never witnessed the private ceremonies. And all religions, as you know, have private and public ceremonies. That's something that's common to almost any religion. So that's an issue of it. And in fact, most of the other states on the eastern seaboard fully embrace and recognize Algonquin ceremonial stone landscapes. The State Commission in New York doesn't, but the Empire State Museum does. So they don't even agree with each other, but they also don't talk to each other, and it's sort of a not talking relationship right now. And we have other situations, like in Vermont, there's a library expansion on a known village site of Abenaki up there, where their rights are not getting observed. So it's not just in Massachusetts, it's happening in every state. Even though state commissions may be supportive, there's still a problem to get these things enforced on the ground. And then the social situation we have now with Standing Rock and with the new administration is such that we have an administration that's trying to abandon all legal obligations, to put it simply. They placed someone, as we've talked about, in the EPA who has made very public statements about being essentially against the EPA as an idea. It is against the idea of protecting our environment from contamination and abuse. They're trying to abandon legal restrictions on any kind of development. And you can look at that how you want, but you know, it's suffice to say that we're not a newborn country as a nation anymore. It's a myth that we ever were, because there were many civilizations that came before us here, and 10,000 plus years of occupation in this area, in this immediate area, which is about as long as it's been free of glaciers in the first place. Like as soon as the glaciers retreated, Native people were right on the edges of those glaciers, and the archaeology shows that. But in any case, and much longer south and west of us too, where we have much, much older sites. You only have to go as far as Pennsylvania to find the Meadowcroft site, which goes back 14,000 years. So that's right to the point where some people say Native Americans arrived in America, which is a subject I don't want to really discuss or debate. I don't see any need to prove anything about that. We're the first people here, and that's all there is to it. There's no genetic evidence otherwise. Europeans never feel like they have to argue that they're indigenous to Europe, although you could really make an argument that they're not on the same basis. And so I don't feel like we need to either.
Yeah, you don't have to make an argument that people are from where they're from.
Exactly.
For the rest of the world.
No, not it's a unique onus that's thrust upon Native Americans that they love to question our origin. And people love to supplant a race before us here, where you could very easily argue the same way in Europe and say, well, obviously the Cro-Magnon who came out of Africa to Europe are Africans, and so the indigenous people of Europe are African. And actually, when you look at the like Cabala Sforza and others who have done genetic mapping of the human migrations, Western Europe and West Africa have a genetic closeness that is not shared by Eastern Europe and East and Southern Africa. So it's a genetically valid argument also to say that West Africans and Western Europeans have a common origin. Of course they do. Humans have a common origin in Africa, but we have a more recent shared origin, which is probably something that some Western Europeans probably don't particularly care for, but the genes say differently. And then again, of course, North Africa and Europe are extremely genetically close. There's a whole bunch of darts that you could throw at the balloon called European Indigenous to Europe that could pop that balloon. But you can certainly place, Caucasoid people on the fringes of Europe around about 27,000 years ago, which is enough for me. And I don't see any reason to pick it apart. I don't see any reason to undermine Europeans' self-identifying ideas about their indigenousness. I don't see any need to do that to Africans or Asians or Austronesians or anybody else, and I certainly don't see any reason to do it to Native Americans. What I think makes people indigenous, and this really is kind of a paraphrase of the defining scientific principle, is that their culture, their genetic profile, and their identity as a people is formed in the place that we call indigenous, or their indigenous zone. So certainly Native American language, culture, and genetics have a basis here, just like the others do where they are.
Yes. And I want to ask, what nation is it that you find your ancestry from?
Okay. The majority of my Native ancestry it all comes through my father's mother, my grandmother. And she was actually mostly Mohawk, which is not a nice word. Mohawk is a Abenaki word that means cannibal. And they had a traditional conflict, so they had, nice names for each other, like most ethnic groups do. They like to call each other names, which is something people do in modern times, and a certain unpleasant habit that humans have. But properly speaking, they're Ganyankahano, the people of the White Crystal Place, or more specifically, she was Akwesasne when she was from Akwesasne, which is where the partridge drums. It straddles the border between upstate New York and Quebec, in the St. Lawrence and on both coasts of the St. Lawrence. And but she happened also to have descended from Nipmuc refugees from this area, which is not that unusual in that almost all of the peoples of this area from several tribes were forced out during King Philip War by massacres and savage attacks. They found refuge with neighboring tribes who were in a better situation, like the Mohican, Mahakani, from New York, what is now New York, like the Schaghticoke, with the Narragansett, with the Abenaki, who were in a better situation at the time. But then they were attacked again, and in the end, the Abenaki lost all of their land through violence, and the Schaghticoke were forced to flee and stuff. And they were made refugees several times in succession, ended up at Odanak, which means the village in Abenaki, or at the village, which was also called the St. Francis Mission in Quebec, in southern Quebec, which was a Jesuit mission. And they were given shelter there, and then Rogers Raiders attacked even that refugee camp. They fortunately got warning through a couple of Mohican scouts, and most of the people fled, and the people who stayed behind were just like the elderly and the sick, and some women who stayed to take care of them who didn't want to. And also probably some people who were just sick of fleeing. They had been made refugees several times over, and people reach a point where they say, I'm not going, I'm just going to die here, I'm not going to flee again. And so a handful of people were killed, but the rest fled to what's now called Cornwall Island, which is part of Akwesasne. And they were given, and this is an interesting thing, they were given refuge by their enemies, the people they called the cannibals, which is, you could find there's a lot of contest and animosity between groups, but when push came to shove, they would give each other refuge. And then they married in, and for that reason, I'm part Mohawk and part Nipmuc. And my husband Jim, his family on his mother's side are descendants of Stockbridge Mohicans, who again, and that group is actually made up of refugees from several groups, including Natick, Nipmuc, and others, Mohicans, but also Munsee, Delawares, and Nipmuc, and possibly others. So when it comes to East Coast Native Americans, especially people from Western Massachusetts and Southern New York and Connecticut, we tend to be hybridized. We tend to be part European or part African or both, or all three, and we tend to be of more than one tribe. And you find that again in Oklahoma, because these are people, scattered nations, looking to reform and looking for somebody with whom they could form a marriage that would be close to home. And it's that simple.
And well, Massachusetts was a very heavily populated area for Native Americans before the colonizers arrived.
Oh, yeah.
So and now you barely see anybody or any reservations around.
Mm.
There are very few reservations around the area, I believe, right?
Yeah, it's true. Our land base is really tiny in the state, and it's true, especially the Massachusetts Bay Area and the Connecticut Valley were extremely heavily populated at time of contact, and There may even been some problems arising from what you might call overpopulation at that time. It's a situation that lent itself to epidemic in the sense that European had suffered, or Europe had suffered a number of epidemics, and as soon as fishing ships showed up on the coast, there was actually an epidemic that preceded the Pilgrims, which people know about, and so that knocked down, those epidemics knocked down the population hugely, and it's actually used as a tool against us, and the massacres we talked about. So that by the time we get to 1780, from between 1630, or I'm sorry, not 1780, but 1680, from 1630 to 1680, the native population of Massachusetts probably fell by close to 80% or more. And then the subsequent years leading up to the early 1900s really didn't help much. It's actually a continual slow decline. The violence didn't completely stop. The deculturalization and the dispossession didn't stop. Some of the Nipmuc people have talked about hiding in plain sight. People took to being as Anglo as you could. People married Anglos. They took Anglo names. They dressed and employed themselves the same way they sort of hid. Other people married into African American families who were already socially marginalized, but they were given a sort of carved out a little space in society for those people, and they were able to find refuge that way. And so, coming into modern times, we had the Hasanamisko or Hasanamesit, there are two ways. So the current situation involving Native people in the state of Massachusetts is that we have, I believe, 2 state-recognized tribes, which are, it's actually technically a commonwealth. The Hasanamesit, also called Hasanamisko Nipmuc, who are, based near in Granby, where they have some land that they've been able to hold on to all this time. But it boils down to a handful of acres. I don't remember exactly how many, but not many. And then there are the Chibanagangamog Nipmuc, who are based near Webster, where they again, I believe it was a donation by a non-native person, gave them a piece of land back, and they had some small land base that they had been able to hang on to. And that's one of the issues of getting recognition, is that if you can't hang on to a land base, they annihilate you. So it's bizarre because that would have annihilated the Jewish people as a people, who for 1,200 years had no land base. So you have to consider that reality. And of course it almost did happen to them, as marginalized as they had become. And even though they tried to reestablish themselves in a different land, their tenure there was always at risk, and there was a lot of history for that. So that happened here too. And at one point, the Nipmuc did gain federal recognition, which cost a huge amount of money, and I think they filed 72,000 some odd documents or something like that. So a huge amount of legal work and effort, and a ridiculous burden of self-proof. Whereas, just to give this a fair parallel, and to put this in context, as an African American, you can claim any rights and privileges assigned specifically to African Americans without ever proving you're an African American. You need no documentation, you need no proof. You can self-identify as Black or African American anytime you want. In fact, my children are African American, as well as Native and European. It used to be, until recently, it was illegal to self-identify on the census as mixed race. Something that I fought with the census all my life about, and I invited them many times to take me to court and sue me, but they never did. Then they decided probably to change their minds about that because it would be less expensive than suing all the people who defy them. Because it also put my children in a completely untenable situation where they had to pick between one of 3 races. And it is an absurdity to place this upon them. They don't belong in a racial category, and they shouldn't be forced to endure this abuse of themselves and their identity, where they're constantly re-identified by different people and forced to make choices. But fortunately now you can identify yourself as a multiracial person, which is something that I think people need to embrace, because when you put a fine genetic point on it, I think you can argue that almost all people around the world are multiracial. Most Europeans have some Asian blood in them or some African blood in them. Of course, we all have African blood in us, but I mean more recently. When you look at the Indian subcontinent, it's a place of, even though there may be racial tensions there and ideas about caste, there's no denying that the population there is very much racially mixed. It's hard to go anywhere in the world and even take a small nation and with any truth say that this is a pure lineage people. Because that idea of purity is a myth amongst humans.
And even race is a social concept.
It's a complete social construct. We were talking about the other day, like people recognize 3, maybe 4 races, whereas even at the beginning of the 1900s, anthropologists were talking more in terms of about 9 races, many of which people wouldn't even be able to identify or associate with anything because they never heard of them. And then, yeah, when you start putting a fine point on it, race sort of dissolves logically when applied to testing, genetic or even anthropometry. I think I said that right, which is the measurement of human physical features. So so to go back, Native Americans are the only people who have to document the race. You can claim all white privilege by just saying you're white. People, if you look pale enough and people accept you as white, you're in. You can be African American and claim, programs that are actually designed to assist you without ever having to prove anything. You're Latino because you say you're Latino. Nobody has to prove anything. The only people who have to prove something are Indigenous people, which is a specialized burden and therefore, unjust and illegal, because it's prejudicial and confers less than equal protection. But we do, and that's what we're saddled with, and one of our burdens in life now. So the Nipmuc gained federal recognition through great expense and effort, and actually those efforts divided people, because under the tensions of trying to do these things, people come up with a lot of conflicts, and then they lost it. They lost their recognition 2 years later. So you are valid and real today, you're not valid and real tomorrow. It's absurd.
Because of political whims.
Because they changed presidents and they lost their recognition.
And may I ask, how many people are part of?
About 1,500 people, I believe, are registered with the Massachusetts Nipmuc tribes, who include the Natick, who are an old group that started even back with the missionaries, and muchly abused people because during King Philip's War they were deported to Deer Island, where they were basically left to starve and freeze to death. And then there are several other groups who probably have no hope of being recognized by anybody at this point. And there are intertribal groups like the Native American Intertribal Council of Western Massachusetts, who give community to all those people who are displaced from their home group. They may be Native Americans from another place in the country and don't have any means of being integrated with them. Or they may be people who don't have tribal membership because they can't prove their tribal lineage. Or they may be, in fact a lot of them, are people whose tribe no longer exists officially. I'm part Nashaway Nipmuc, the Nipmuc who are from this part. There are 5 Nipmuc divisions in Nashaway, the Quaboag, the Quanabesset, and like this. Anyway, our people as a people are so scattered and few that we have no body. There is no Nashaway Nipmuc body anymore. So the Native American Tribal Council of Western Massachusetts brings together people who have been scattered by diaspora and whose national identity has been crushed asunder, and gives community back to those people. We endeavor to, I'm a member, and so is Jim, and we endeavor to try to sustain culture, try to give education to people about our culture, and to try to provide community and address Indigenous issues where there is no political body to address those issues for us. And then again, there are the Stockbridge Mohicans, Stockbridge Munsee Band, have their land, Mohicaniac, out in Wisconsin, which I think the Menominee gave them some land. Another case of unrelated or distant related tribal group just giving land to other Native Americans in that kind of hospitality, just like we gave land to pilgrims and everybody else. And so they're way out in Wisconsin. There's some in Oklahoma, and there's some in Ontario. There's the Sakoki Abenaki, some of whose land is in northern Massachusetts, who are based mostly in Vermont, and other groups and the Pocumtuck, who were so decimated that it's even hard to find people who are Pocumtuck descent, although I may myself be of both Nipmuc and Pocumtuck descent, because in the area where we're talking about, in this area actually, the two nations, to my eye, from my study, seem to have sort of blended together to a certain degree, and I think very much intermarried, or at least on the level of the Sakums appear to me to have intermarried, which wouldn't be unusual. So that's where we stand today. I think the two the two state recognized bands comprise 500 to 700 people. I'm not sure if I have those numbers right, because I don't often look at the numbers. I think about 1,500 people in the state claim descent from nations within the state, not including the Mashpee Wampanoag, who have recognition, federal recognition, and the Quina Wampanoag. I think the Mashpee just has state recognition, I'm not sure about that. But the Quina Wampanoag have federal recognition also. There are Mashpee Wampanoag, and there are other Wampanoags who survive but are not necessarily part of those two groups. There were a number of Wampanoag groups that no longer survive as political entities today.